So, welcome back to Land Law Made Simple, a series where we have a look at important concepts in land law, and I try to break it down into really simple terms, making it a bit more accessible to laypersons, students, anyone who might be interested in land law. In the last lesson, we had a look at easements and what they actually are. So you might want to check that out if you haven't seen it yet. In this lesson, I will focus on different methods how to create an easement. So let's get started. As you can see here, there are 6 methods for creating an easement. Some of them are a bit easier, some are complicated, but it is good to know all of them. So we go through them bit by bit to cover any kind of differences, any overlaps, what's really important to remember, and so on. So the first one we look at is an express grant or reservation. So express, that obviously means that the landowner needs to be quite deliberate and clear in order to create the easement, and this is something they do by a certain act which has to be intentional. Some of the other methods can be unintentional as well, but this one is the most complex and formal one, I think, and so it is a bit more difficult to do as a layperson. You will likely require a solicitor to help you with that. We distinguish between grants and reservation. So what is a grant? This is where the landowner deliberately gives someone else the easement, so a right to use their own land. So for example, if I have a nice country house with extensive grounds, I could say to my neighbour, look, I will give you the right to cross my land so that you can reach the road, and yeah, this is something I'm doing deliberately in this case. I'm granting the right to another person, but in this case I keep owning the land as before. The only thing different is that now sometimes the neighbour can walk across the country and get to certain places, but the ownership obviously remains exactly the same. Now a reservation is different in that the landowner keeps back a certain right when selling the land. So for example, if I have a huge piece of land and it's actually a bit too big, I don't need all of it, so I sell part of the land to someone else, but I then say, well, I still need to access it from time to time to get to certain other places or to do some maintenance and so on. So even though I'm giving away the ownership rights and the other person is now the legal owner, I still retain some limited right to use the land. Okay, so that is the main difference. So with one, I'm just giving this to someone else, and there's no change of ownership at all. Whereas with the reservation, keeping or retaining a right when the ownership changes. Both of them need a deed. So remember, that's a formal legal document with quite a lot of formalities, including that it has to say it's a deed, there needs to be signatures, there need to be witnesses, so lots of formalities here, which might mean that this method of creating an easement is not quite as attractive and accessible, really. But it's still important to remember and to distinguish both of them. So grant is giving a right to someone else, and reservation is retaining the right for yourself, despite parting with the land. Okay, right. Let's move on to implication by necessity. And this one is quite a rare one in real life, to be honest. And the reason being that this only happens when the land would otherwise be completely useless. And I mean useless, it's not anything like convenience or making things a bit easier, nothing like that. It has to be something that is of complete vital importance, and the land wouldn't really work without this easement. Okay. The main idea, the main time this might happen is if you sell someone a piece of land like a field or a barn or something, but your own land still surrounds it, and the barn or whatever that you sell is completely landlocked. There's no access via public road, and the new purchaser obviously needs to have a way to get to the land, and this will likely be then an easement to walk or drive or whatever across your own fields that you retain. Okay, so as we can see from this example, if there's a landlocked field and there's absolutely no access whatsoever, then this would then create an easement by necessity. If there's another way, but it's just a lot more, a lot longer, more difficult, even really dangerous, that doesn't matter at all. As long as there's a different way to access the land, it obviously means that the land wouldn't be completely useless. So in that case, there wouldn't be an easement implied by necessity. This is really a black and white matter, and any kind of greys or shades in between don't exist. It's all in or nothing. Courts are really, really strict, so any other way that you could avoid or circumvent and still use the land without the easement, that blocks it. Okay, and it only exists when without it the land would basically be dead. Okay. Right, next one is also an implied easement, so it doesn't really require any formalities, but it is a lot easier than the implication by necessity. So implication by common intention is kind of self-explanatory, and it arises when both parties clearly intended the land to be used in a very specific way, and the easement is just incidental to this. It's essential to make sure that the land can be used in the way it was intended. And there is a famous court case here which illustrates this point a bit, and it was that the owner of the property created a lease, so someone had obtained the rights to use the building for a restaurant that they wanted to run, and the lease very clearly said that the property had to be run as a restaurant, but it also said that there shouldn't be any kind of noxious smells being emitted. And obviously this is a bit contradictory. In most restaurants you will probably get a bit of smelling. I don't know, especially if it's like I don't know, some kind of curries and stuff, or shawarma or anything. So the only way to avoid having all of those noxious smells really is to have really good ventilation. And this is what the people actually did, who got the lease. They built a ventilation duct, and part of this passed through the landlord's building. The landlords obviously weren't very happy with that. They didn't want a ventilation duct to be in their own part of the building that they retained. But the court said there was an implied easement because both parties decided that they wanted to have a functioning restaurant and that they would have to do something to avoid smells. So because of this necessary obligation to avoid the smells, it was implied that the new owner of the restaurant should then be able to take certain steps like building the ventilation duct. Okay, so this is probably fairly easy to remember. If there's a shared purpose that unites both sides, then this can also create a shared access if it's really necessary to maintain this common intention or common purpose. Okay, now we move on to some of the more tricky and complex methods for creating an easement. And one is the rule in Wheeldon v. Burrows. And this converts something we call quasi-easements into real easements when land is split. That's kind of the short way of saying it. But what do I actually mean by this? So a quasi-easement is a right that could actually be an easement, has all the functions of an easement, like walking across a certain path to a field or something like that. But the matter is that there's no dominant and servient land. You own all the land by yourself. So obviously, as you might remember from last lesson, an easement really requires a dominant and servient land that are being owned by two different parties. And so if that doesn't exist and one person owns all of the land, then we call this a quasi-easement. Okay, so for example, if I have a large piece of land with a big main building and some kind of other buildings as well, maybe a shed, a barn, a garden house, a pool house, maybe even some kind of playing fields, a basketball court, wherever. And I walk to those different old buildings all the time, then this is basically a quasi easement, because I'm using this right of way over my own land, and it could potentially have been an easement, but at the time it is not, because I'm the only owner. Now, when I then decide to sell the cottage or sell whatever other part there is, and I split the land, now suddenly all of the requirements for an easement are fulfilled. And this means that an easement is basically created automatically. And the most common example that you will see in exams and so on is when a certain cottage or barn or whatever is being sold with a well-worn path across the retained land, and so this would automatically create an easement as long as the key conditions are fulfilled. Okay, so you might think of it as there is like a certain right hovering over the land or floating, and this then crystallizes at the point in time when the land is being split, so either like sold or leased or something like that. Now there are some conditions for this to apply, and those are, for one, that the quasi-easement needs to be continuous and apparent. So what this means is that there needs to be some kind of visible manifestation of the right. So for example, if I walk across a part of my land to an outbuilding every day for years, this is obviously creating some kind of footpath or way or bridle path, something like that, which is quite visible. Otherwise, it could also be drains or pipes or windows which kind of show to any purchaser that there is an existing right there. Okay, so that's what we mean by the first condition, to be continuous and apparent. It must be visible and it must be permanent in character. Now, the second condition is that it must be necessary for the reasonable enjoyment of the land. So in contrast to what we've seen before about the implication arising from necessity, this is now a lot more lenient, and we don't necessarily mean that the land would be completely useless without. It's just something that is more convenient and useful, and where other purchasers might say, yeah, it's not absolutely necessary, it's not crucial, I could manage without, but it is still quite good to have, and it kind of increases the value of the property, really. Okay, and then lastly, it has to be used by the seller at the time of the sale, so it should be something that is quite current. It doesn't work if I don't know, my parents used the right of way for the last couple of years, but then we kind of stopped using the footpath. It's starting to get really overgrown. Nobody's using it anymore. Then that would kind of prevent me and Burrows from applying. if the quasi-easement isn't actually being used for quite some time. And the thing is with Wheeldon versus Burrows, this will kind of apply automatically, except if you expressly excluded in, for example, the lease agreement and so on. So if your contract says we won't imply any easements, then this prevents Wheeldon v. Burrows from applying. Now let's move on to Section 62 of the Law of Property Act, and this is kind of similar to the previous ones because it also automatically passes certain rights and privileges if you transfer the land to someone else. So there also needs to be some kind of split in or transfer of property rights. And the difference to Wheeldon and Burrows is then that this can also be for minor things like small permissions. There hasn't necessarily got to be any continuous and apparent use. Even really minor things can be turned into a full easement when the land is sold. So for example in Wright v. McAdam, this is obviously a bit of an older case, but the tenant used the landlord's coal shed and they had the permission to use it. So when the landlord then leased the property again and renewed the lease, this turned into a full easement automatically, and the tenant's rights were then protected in certain ways. Okay. Basically, you can think of this as personal licenses and personal permissions, which are then being elevated or crystallized, solidified into actual easements. This could be something like the permission to use a coal shed. It could be also something else, but the main thing is that there's a personal license that hardens into a legal easement and is now becoming legally protected at the point of conveyance or the point of sale, point of lease, and so on. And as I mentioned before, the difference with Wheeldon versus Burrows is that we don't really need to prove all those three conditions. We don't need to prove continuity, we don't need to prove apparentness, we don't need to prove necessity. It will be something that happens automatically through this statute. Now, there are still some requirements for Section 62 APA to apply, but these are a lot easier to achieve. One is obviously, as I said before, there must be a conveyance of land, so a grant, a lease, or a transfer, for example. There must have been a kind of license or quasi-easement or even just a small minor permission in existence at the time, and this must still be in use at the time of the transfer. Actually this covers not only just small, doesn't just only apply to easements that are being granted and that are necessarily easements. It can also apply to something that was first labeled as a license or a quasi-easement and is then being lifted to the status of an easement and gets more of a protection. But this then obviously means, since they are now being lifted into easements, that we must make sure that the conditions for easements from i.e. Edinburgh Park need to apply. So the right must be capable of being an easement. And that's something you can have a look at in the previous video, where I explained a bit more about i.e. Edinburgh Park and the conditions that might make a easement capable of being granted. Okay, so definitely have a look at this again if you're unsure. Again, this can be excluded in a deed. So if you don't want this to apply, then you should write this into your deed when issuing the grant, lease or transfer. Now we get to the final method, and this is prescription. You might have heard of the term before from torts, for example, and it does work similarly, but it is still a bit more complex, and not a lot of people want to rely on this because of all the formalities and requirements. So it arises if someone uses a right of land really openly for 20 years and there's never been any issue, there's never been any dispute, the landowner never took any steps to prevent this. So the law then says, well, if you haven't done anything about it for 20 years, then we will now protect it as an easement. And there are 3 requirements, which are: it must be without force, it must be without secrecy, and it must be without permission. And sometimes people use the Latin terms for it, so nec vi, nec lam, and nec precario. But you should be alright to just use the English terms, so no force, no secrecy, no permission. So let's step back a bit and look at everything in more detail and explain what is actually meant here. So the core idea is, if you've openly used someone else's land for a long time, normally this is 20 years, sometimes it might be 30 years or 40 years depending on the case, but typically it's 20. Then the law will presume you have acquired an easement. Why? Obviously because the landowner tolerated it for such a long time, 20 years, without ever objecting. So the courts will then just say, it just looks like it's been lawful all along. And so what you really need to do is to use the land as if you already had the right, and the owner is then being silent, he doesn't intervene, so it looks like there's an approval, really, or at least an acquiescence. But let's look at those 3 conditions in more detail. Okay, so no force is pretty self-explanatory. You cannot just use any force like breaking and entering or destroying a gate or something like that to basically just grab the rights using violence, that would definitely not be protected by law. So if you smash a gate every time to use the path, definitely no easement. And even something that's a bit more subtle, like chaining a gate open, will probably prevent prescription, but obviously this is a bit of a matter of degree, and what amount of force might be too much and what is still acceptable. Now, the second one, without secrecy, should also be fairly necessary and self-explanatory, because we are assuming that the landlord is actually tolerating something for 20 years. They are aware of it, but they aren't actually doing anything about it to stop it. And this means that they must reasonably be aware of the situation. If you only walk across someone's feet at night when everyone else is asleep, then they can't possibly know that you're using it. That's too secretive, and the law wouldn't then step in to protect it. So really the idea is that the owner must have a fair chance to do anything about it and to actually stop the easement, or the right if they don't want it to become protected by law. The last one, that's the one that's a bit more tricky to understand, and it says that the right must be as of right and not by the owner's consent, which does sound a bit weird because honestly normally consent is such a big part that we need to have, but not in this case. And the idea behind it being that if you actually gave a formal permission, then this isn't actually something that we would label an easement, or at least not an easement by prescription. It would then more likely be a license or a grant or something like that. So that's the reason why we say it can't be by consent or permission, because it's just a clash of terms really, and you would normally use a different label for it. So what you might think about it then is that prescription is about converting a tolerated trespass into a legal right. Okay, it's just something that is being tolerated. There's no actual permission, no actual grant, nothing express, but just something that is being tolerated by the owner of the land. Okay, so there are 3 types of prescription, and each of those are a little bit different. We have at common law a presumption that if a certain right has been there since what we call time immemorial, so since 1189, then this will automatically be lifted, upgraded into an easement. Now, obviously, this is a really, really long time that in theory we would have to show since 1189. So that also means that it's really difficult to prove, and hardly ever do we have anyone trying to rely on prescription at common law, because it's just so easy to rebut it. The only thing the landowner would have to do is to show that since 1189, at some point in time, the right wasn't actually being exercised, or it wasn't anything that was an actual thing capable of being an easement. Maybe at some point in time since 1189, all the land was being owned by the same person. So there's a lot of different ways you can rebut this presumption, and it's just almost impossible to prove. Now, the second one, which is kind of the go-to doctrine, really, is something we call the doctrine of the lost modern grant. And this is based on the common law, but it recognizes that actually this is so difficult to prove, 1189. So the courts have basically just come up with some code of fiction that in those cases there must have once been a deed that actually expressly granted the easement, but this deed has actually just become lost in the meantime. So if you can show that the easement or the right has been used for 20 years, then the courts just pretend that sometime in the past there must have been an express grant behind it. Even if you can't show this express grant, or it might never have existed, that's just a bit of a weird fiction that courts imply to make things a bit easier for tenants and so on who are using a certain right of land for those 20 years. Now, since this is a bit of a weird fiction go-to doctrine that is really a bit of a joke if you think about it, there was an attempt by Parliament to make things a bit more easier by introducing the Prescription Act 1832, which is kind of the statutory version of the doctrine of the lost modern grant. And it also does say that after 20 years the right can be established. And the thing is, it's a bit more complicated. The wording of the statute isn't great. It's quite hard to understand. It's got different levels as well. Like you gain some rights after 20 years, and then almost absolute, really extensive rights after 40 years. So all of those complexities and so on mean that the Prescription Act 1832 isn't used very often in real life, and the courts rely to a large degree on this doctrine of the lost modern grant. Okay, so the main thing you should be able to remember is that there's 6 different ways of creating an easement, and you should roughly know what they are so that you can distinguish between them. You probably in exams will need to know all the ins and outs and minute details and requirements, but you should be able to distinguish between them. So the express grant or reservation, where you need a written agreement, the necessity, common intention, the doctrine in Wheeldon versus Burrows, Section 62, which is a statutory transformation into a right, and lastly the prescription, where we have a long period of 20 years where the right has been open and used as of right. Okay, so this is the really important bit that you need to remember, this overview on here. I hope this helped to explain things a bit more. If you've got any questions, just put them into the comment section.